News of the times. Too drunk to hang. The brutal 1909 murder that changed British law. Welcome to News of the Times. In this notorious November episode, we examine the grim case of Thomas Mead, a Leeds labourer whose drunken and brutal killing of his partner, Clara Howell, shocked Edwardian Britain. The details were harrowing. Clara's body was discovered nude, hidden under old rugs and described as one great bruise from head to foot. Mead had struck her in a fit of rage over a missing 2-shilling piece. He confessed repeatedly to friends and neighbours, and yet, when brought to trial, he pleaded not guilty to murder. Why? Because he was drunk, and at the time voluntary intoxication was still being used to soften murder charges. But the Crown pushed back, and Regina versus Mead 1909 would help end the so-called drink defence in British law. Join us as we explore the crime, the courtroom drama, and the moment the bottle met the bench, a sordid case that became a turning point in legal history. And in today's end of episode further particulars, a lonely Victorian suitor, a mysterious young lady with a firm handshake, and a moonlit proposal that ends with an unsuspected revelation and rather fewer petticoats than anticipated. So, stoke the fire, draw the curtains, and pour yourself something fortifying as we step back into the shadowy streets of Edwardian Leeds, where the law, the bottle, and the noose all came into play. Before the Edwardian case of Thomas Mead reached the courts in 1909, the British legal system had long wrestled with the deeply uncomfortable question: can a man avoid punishment for murder simply because he was drunk? For much of the English legal history, the answer was firmly no. The long-standing principle, going back at least to the early 17th century, was that voluntary intoxication was no defence to a criminal act. If a man chose to drink, he was held responsible for whatever he did while under the influence, as if he had been sober. In 1819, however, legal thinking began to shift. Courts began to distinguish between intentional and unintentional acts, even in cases involving drink. The idea emerged that if a person's mind was so clouded by alcohol that he could not form intent, the charge might be reduced, for example, from murder to manslaughter. This opened the door to a wave of murder trials where the drunken defendants claimed they hadn't meant to, that their violence had been unplanned, fueled by spirits, not by malice. And so, into this murky legal landscape came the Regina versus Mead, a Leeds gasworker who beat Clara Howell to death after accusing her of taking 2 shillings. He admitted the crime repeatedly, but in court he pleaded not guilty to murder because he'd been drinking. The question facing the judge was stark. Was this man truly incapable of forming intent, or simply hoping that drink would shield him from the gallows? It was the 28th of November in 1908. A disturbance was held late that night in Crook's Yard. Raised voices, perhaps a quarrel. Then all went silent. Days passed. Neighbours grew uneasy. No one had seen the quiet, cheerful Clara Howell, and so, at their urging, the police forced entry, clambering in through a back window of the small, bare flat she shared with Thomas Mead. What they found was horrific. Clara's naked body lay hidden beneath rugs and old matting, her arms and torso a mass of bruises and abrasions from head to foot. This was no sudden accident. This was a killing born of rage. From the Yorkshire Post and Leeds Intelligentsia on the 1st of December 1908, the sordid tragedy in Leeds. At the Leeds Police Court yesterday, Thomas Mead, 33, a gasworker, was charged with the murder of Clara Howell, 36. Detective Superintendent Handley, asking for a remand, stated that the accused and the deceased had cohabitated together for 7 years, and during the last 15 weeks they had resided at 3 Crook's Yard in Wells Street off West Street. On Friday night last, they returned home together. Shortly after their arrival, a neighbour heard a disturbance, but no importance was attached to it. The neighbour, however, did not see either of the parties afterwards, and in consequence of a statement made by another neighbour on Sunday afternoon, the house was entered by Police Constable Carbutt. Under some sacks in the bedroom, the nude body of Clara Howell was found. It was a mass of bruises, and there were signs of a violent struggle having taken place in the lower room. A chair had been smashed and other articles had been broken. The movements of the prisoner were traced, and he was arrested on Sunday night. Although on the surface it may have appeared to be yet another sordid domestic tragedy all too familiar to the courts of the day, but there was no escaping the brutality of what Clara Howell had endured. Even seasoned investigators were shaken by the sheer violence of the scene. A home in disarray, furniture broken, and Clara's body concealed beneath sacks, showing signs of a sustained and merciless beating. As the inquest got underway at Leeds Town Hall, a picture began to emerge, not just of what had happened, but of the man responsible and his astonishing statements in the hours that followed. From the Yorkshire Evening Post, the 4th of December 1908, the Leeds tragedy. Prisoner's exclamations in his sleep. Remarkable evidence at today's inquest. At the Leeds Town Hall today, the city coroner, Mr. J. C. Malcolm, resumed his inquiry into the circumstances of the death of Clara Howell, aged 36, the victim of the sordid tragedy perpetrated in Crook's Yard off West Street in Leeds on Friday night last. Dr. Humphreys said that he had examined certain articles on which he found bloodstains. On a broken broom handle there was also blood marks and human hair. In witnesses' opinion, the woman was probably devoid of clothing when the injuries were inflicted. Margaret Shuttleworth, married woman and at present staying with her parents at 5 Lisbon Court in Leeds, said that at about 10 minutes past 9 on the night of Friday last, the man Mead, who is in custody in connection with the crime, came to number 5 Lisbon Court, accompanied by the deceased. There were others present, and the company had both beer and whisky. The two left at about 11:15. Mead appeared to have had plenty to drink. That was the last time the witness saw Clara Howell. On the following day, Mead came to the house about 7 in the evening, and he said, "Will Mick," meaning the father of the witness, "let me have a sleep?" Witness told him to lie down on the sofa, and this he did. She noticed that one of his eyes was bloodshot and said a man had done it that afternoon. Later he was asked where the deceased was, and he replied that if Mick knew what he had done, he would not let him stop there. He also said that he'd killed Clara and had given her 2 black eyes, and that she was at her sister's at Newton. His story was not believed. Witness went to bed at about 11, and during the night she heard some shouting in what she thought was the prisoner's voice. The words used were, "Poor Clara, I've killed you." While the prisoner lay on the sofa before the witness went to bed, she heard him say, "I know I will be legged. I will be hanged, for I have killed Clara." He also said, "Take this rope off my neck," and put his hand to his neck, complaining that the rope was tight. Witness did not know whether he was asleep or not, but he was lying on his back and his eyes were closed. The next day he again said that he had killed Clara, and that as soon as it became dusk he would make his way to Bradford. Witness after witness took the stand, each offering their own piece of the same grim puzzle. Again and again Thomas Mead was heard confessing to the killing of Clara Howell, sometimes in anguish, sometimes in apparent remorse, and at least once with what sounded uncomfortably like pride. One statement suggested he had done the missus in because she had taken 2 shillings from his pocket, a grievance that, in Mead's retelling, seemed to swell in significance with each repetition. "I've done the missus in." Later in the day, a little girl came running in and said that a policeman had entered Mead's house in Crook's Yard and had found Howell dead. Mead jumped up with an exclamation and, after asking for his cap, made off. Robert Prust, labourer employed at the new Wortley gasworks, said he had known Mead for about 7 years. On Saturday he met him in the street at about 6 in the evening. Mead said to him, "I have been in yond boozer," meaning a public house. He said a man had hit him in the left eye, and he further said, "If I could have got hold of him, I would have pulled his throttle out and swung for 2 instead of 1. I've done the missus in, Bob." This he repeated 2 or 3 times, saying that they had a bit of bother and that he had left her as dead as a mackerel. The prisoner's account of his doings. John William Prenderville, 56 Langham Street, New Wortley, said he saw Mead in the Railway Hotel, Spence Lane, on Saturday evening. After having a drink, Mead said to him, "I've done the missus in. She took 2 bob out of my pocket and I hit her and she fell to the ground. I went to bed and the next morning I found her moaning and groaning." Mead further explained that he carried her upstairs and that she lived for about 5 minutes afterwards. He stopped with her until about 9 o'clock, then went to the gasworks to draw his back pay. Preceding witness said that Mead had become involved in a fight, after which he met Mead outside, the latter remarking that he was going to Bradford and he would do himself in. The arrest of Mead. Detective Inspector Wilson said that on Saturday last he and Detective Officer Wright were searching for Mead and they arrested him at about 10:20 p.m. at 14 Chadwick Place, Whitehall Road. The officer found him sitting in the kitchen and the witness said, "I want you." Mead said, "What for?" And witness replied, "I'm going to arrest you on suspicion of having caused the death of Clara Howell at 3 Crook's Yard." To this Mead remarked, "All right." He was taken to New Wortley Police Station and on the way he said, "She is dead as a mackerel. If you had been an hour later, I should have done myself in." Mead was subsequently taken to the town hall where he was formally charged. A verdict of wilful murder. The jury, after a short deliberation, returned a verdict of wilful murder against Mead. As the case progressed through the magistrates' court, the prosecution laid out its case in formal terms. Clara Howell had been murdered following a drunken quarrel over a missing 2-shilling piece, a sum that in Mead's eyes seemed to grow more significant with each retelling. Witnesses again came forward to describe how Mead had confessed to the killing, including the now familiar phrase, "I've done the missus in," reportedly said more than once, along with the chilling detail that he had left her as dead as a mackerel. The defence, for their part, emphasised Mead's drunken state, setting the stage for the key legal question to come. As the case moved closer to trial, yet more witnesses emerged, many echoing what had already been said, but one remark cut through the repetition with particular force. Thomas Mead, according to one account, had claimed not only to have killed Clara, but that he had given her a damn good hiding. The phrase, delivered with what seemed like grim satisfaction, added weight to the argument that this was no tragic accident, but a deliberate and sustained assault. When the case finally reached the Leeds Assizes on February 1909, the prosecution's task was straightforward. Not to prove that Mead had killed Clara, for he had confessed to that many times over, but to demonstrate intent. The Crown outlined the now familiar events: the drunken quarrel over a missing 2-shilling piece, the violence that followed, and the concealment of Clara's body under rugs. Witness after witness described Mead admitting to the crime, sometimes remorseful, sometimes almost boastful. One of the most striking moments came when Mead was heard muttering that he had dreamed he had a rope around his neck, and to police he gave a grim summary of his actions. She made me do it. I gave her a good hiding. I hope to God they hang me. I don't want to live." With that, the prosecution rested, leaving the defence to argue that drink, not malice, had driven him to the act. Mr. Jardine, addressing the jury on behalf of the prisoner, pointed out that he was under the influence of drink at the time, and submitted that they would be justified in reducing the charge to one of manslaughter. His lordship having summed up, the jury retired. Prisoner sentenced to death. After an absence of about half an hour, the jury found the prisoner guilty of wilful murder. His lordship, having assumed the black cap, passed sentence of death in the usual form. The prisoner, who seemed quite unmoved, was then removed from the dock. And so, with little hesitation, the jury returned a verdict of guilty. The judge donned the traditional black cap, pronounced the sentence of death, and Thomas Mead, who had beaten Clara Howell to death over a missing 2 shillings, was led from the dock to await execution. But the case did not end there, because Mead's legal team appealed their argument that while the facts were ugly, they didn't meet the legal bar for murder. He was drunk. He hadn't used a weapon. He'd only hit her with his fists, and, they claimed, without intent to kill. That made it manslaughter, not murder. In plainer terms, yes, he killed her, but not on purpose, and he was too drunk to form proper intent. This was the crux of the so-called drink defence, a loophole that had allowed many men before Mead to avoid the gallows by arguing that the bottle, not deliberate malice, had done the killing. But this time the courts weren't buying it. The Court of Appeal swiftly rejected the idea that drunkenness alone could excuse the level of violence that Clara endured, and they weren't swayed by the suggestion that using fists made it somehow less murderous. It was a quiet but crucial moment in British legal history, a case that helped tighten the rules around when intoxication could be used as a defence for killing. In short, this was the end of the excuse. From the Yorkshire Evening Post, the 22nd of February 1909, leave to appeal on the facts refused. In the Court of Criminal Appeal today, before Justice Darling, Walton and Pickford, Thomas Mead, who was convicted at the recent assizes at Leeds of the murder of a woman named Clara Howell, with whom he had lived for several years, and sentenced to death by Lord Coleridge, appealed against his conviction. Mr. Willoughby Jardine, for the prisoner, said the question for the court was whether or not the conviction should have been one of manslaughter, on the grounds that the prisoner's mind was in such a condition that this reason was disordered. Counsel described the circumstances of the woman's death and said the man's own statement was that he had struck the woman on the nose, and as she was falling he struck her another blow on the lower part of the body. Counsel submitted that the fist was not a deadly weapon, and, therefore, the offence could not be wilful murder. Mr. Justice Walton: then you say the death was an accident? Mr. Jardine: yes, and the evidence showed that the man had been drinking for weeks, and that he had been reduced to such a state that he was all of a tremble, as one of the witnesses put it, and he had no intention of killing the woman. He also submitted that there had been a misdirection of the jury, but on that point he said it was not necessary to go into the question here. The following day, the Court of Criminal Appeal returned with its decision, and it was final. Thomas Mead's conviction for the awful, wilful murder of Clara Howell was upheld. His defence had argued again that fists were not a deadly weapon, and that Mead, in his drunken state, lacked the intent necessary for a murder conviction. But the judges weren't persuaded. In their ruling, they reaffirmed a long-standing principle of English law: a man is responsible for the consequences of his actions, even if drunk, unless his intoxication was so extreme that he was completely incapable of forming intent. The phrasing used by the trial judge, that Mead's reason must be dethroned for the charge to be reduced, was described as picturesque but accurate. And with that, the appeal was dismissed. Regina v. Mead, 1909, would go on to be cited in future cases, helping to narrow the legal tolerance for drunkenness as a defence in violent crimes, particularly those committed against women. From the Yorkshire Evening Post, the 12th of March 1909, the execution at Armley. Leeds murderer and moved to the end. Mead walks firmly to his death. The execution took place at Armley Jail this morning of Thomas Mead for the murder of Clara Howell at Leeds on November the 28th last. Mead was 33 years of age and was a gasworks labourer. The woman Howell had cohabitated with him for 7 years. Latterly, they lived in Well Court off West Street, Leeds, and it was there that the murder was committed. After Mead's condemnation, appeals were heard in London against the sentence, both on a point of law and fact, but they were dismissed. The condemned man was as unmoved at his fate throughout his incarceration as he was at his trial and actual sentencing. Near to death, he spoke little and did not express contrition for his conduct. His appearance improved greatly during his stay at Armley. This morning he made a hearty breakfast and suffered himself to be pinioned by Pierpont and Ellis, the executioners, without the slightest demur. The courageous manner in which he went to the scaffold excited wonder amongst even the hardened officials. He did not speak on the scaffold, and his death was instantaneous. A number of women and children gathered at the lower end of the street leading to the jail, and dispersed when the tolling of the bell announced that Mead had been executed. And with that, the sentence was carried out. Thomas Mead was hanged at Armley Prison on the 11th of March 1909, his name now etched into legal history, and Clara Howell's suffering the catalyst for long overdue change. Further particulars. From time to time, the archives offer us a brief and brutal tragedy, and then, as compensation, something of a different sort altogether. This week's Further Particulars takes us not to the gallows, but to Croxdale in County Durham, where a Victorian suitor, grey of beard and confident of manner, found himself quite undone by moonlight, matrimony, and a suspiciously strong handshake. Yes, it's another cautionary tale from the coalfields, where religious pamphlets, romantic illusions, and a well-fitted white shawlette all collided in what may be history's most committed practical joke. What began as a harmless flirtation would end in local scandal, class-wide laughter, and one thoroughly humiliated gentleman regrowing his whiskers in quiet disgrace. Let us return now to Croxdale in 1878 and the matrimonial hoax that lit up the village. From the Illustrated Police News, the 23rd of March 1878, amusing matrimonial hoax at Croxdale. The New Year's festivities at the usual quiet and unexcitable colliery village of Croxdale had been greatly enlivened by the discovery and public exposure of a well-contrived and cleverly carried out matrimonial hoax. It appears that for some time a certain very grave individual had been lodging at Croxdale Terrace and working as a hewer at Croxdale Colliery. He was a man past the prime of life, in fact a grey-haired old chap, but his stylish mode of dressing, jaunty air, and open admiration of the fairer sex had made him quite conspicuous in the neighbourhood. Being a regular attender at chapel and class, a constant reader of religious literature, and a very quiet, steady, and inoffensive person, it is not surprising that many of the lonesome widows and ancient spinsters of the locality cast wistful glances at him as they passed him on the road or sat with him in the chapel. But none of these were to his liking. He wanted a young wife, and a pretty one, but having passed the Rubicon, the girls were shy of his grey head, beard, and whiskers. Some 5 weeks ago, however, fortune seemed to favour him, for a pretty young woman looked at him so earnestly one night that he was sure she had been smitten by his appearance. She was in company with a young man who worked next board to him in the pit. But that circumstance only seemed to smooth the way for an introduction to the charmer. The next morning, therefore, Gentle Johnny, as he is designated, inquired of the young man who had the fine-looking girl was that he saw in his company the preceding night. Now it so happened that the fine-looking girl was the wife of the young man, but for a lark he liked Abraham said, "She is my sister." Johnny, therefore, began to praise her good looks and nice manners, and asked his friend if he would mind introducing him to his charming sister, with an eye to further fun. The young man promised to help him in the matter, but said he must first see if she was willing to accept him as a suitor. Then he would tell him when it would be most convenient to come to the house. That night the young man, his wife and her friends concocted a plot to hoax poor Johnny and let the public know that he was already a married man living apart from his wife. Next day, Johnny was informed that his attentions would be acceptable and he could have a first interview that evening, as the old folks were to be from home for a couple of hours. At the appointed time, Johnny went to the house and dressed up in his broadcloth and kid gloves with a grand silk umbrella in his hand. He was duly introduced, and the discreet brother very considerately withdrew and left them to arrange matters. How Johnny conducted himself during the interview is now the subject of universal conversation at Croxdale. The young lady at first absolutely refused to have anything to do with him unless he would first shave off his whiskers and beard, which he promised to do before his next visit. She then promised to meet him at a certain hour on a certain night, dressed in a white shawlette, and have a moonlight walk with her devoted admirer. From this time forth, Johnny and his lady love met regularly, and the couple might have been seen any night on the Darlington Road beyond Croxdale, walking side by side, the arm of the swain fondly encircling the waist of his adorable mistress. Johnny was not so deeply smitten, however, but that he noted some rather strange peculiarities in the manner and behaviour of his charmer. She wore very strong boots, for instance, and walked with a firm, vigorous step, like a female Western, but she explained that she liked to keep her feet warm, and Johnny acquiesced with the trite remark that when the feet were warm, we felt warm all over. Then she grasped his hand at a parting with a grip that almost brought tears to his eyes, but Johnny put this to the warmth of her feelings. Marriage was eventually proposed and the offer accepted. The ring was to have been bought last Saturday, and the ceremony completed by special license, but alas for Johnny's peace of mind, they took their last walk on New Year's Eve. Johnny on that night was more affectionate and pressing in his suit than ever, but the lady reminded him that he would have to go home with her and ask the consent of her parents to the match. Nothing loath, Johnny expressed himself perfectly willing to do so, and the twain at once proceeded to the girl's domicile for that purpose. But the evening appeared to be inauspicious, as there was quite a large party assembled. Johnny, therefore, thought the time inappropriate to prefer his request for the daughter's hand. Not so, however, the lady, for she stood forth and informed the company that he had proposed to marry her, and she desired them all to bear witness to the fact, for she was now going to put his love to the test, saying which she proceeded to divest herself of the bonnet, fall, gloves, shawlet, gown, and other female attire, and presently stood before them in the form of a strapping potter lad known as Tommy. It would be impossible to describe the scene which ensued upon this exposure. Suffice it is to say that the would-be bridegroom eventually made his escape from his tormentors amid much merriment. Since the above event was made public, Johnny had been so unmercifully chafed that he had threatened several people with personal chastisement. He has sought the protection of the local policeman and got the viewer to give a general notice that anyone interfering with him in future will be discharged from the colliery. It should, however, be known to all men and women who it may concern that he is again cultivating his hirsute appendages and presents a very grisly appearance in his woeful devastation. If you've enjoyed this descent into Edwardian grimness, do consider liking, subscribing and sharing, ideally with one friend who collects Victorian crime trivia and has opinions about 1909 jurisprudence. It helps us to stay one step ahead of the YouTube algorithm, which much like Thomas Mead, doesn't respond well to reason, but can be swayed by numbers. And no, hype is still not the name of a new dance craze. We check. If you'd like to dive even deeper, join us over on Patreon, where we've got daily drops over 750 episodes to choose from and absolutely no ads in sight. From true crime to nostalgia, scandal, and everything in between, it's like rummaging through a particularly eccentric aunt's attic, only with fewer moths and more murder. 1 week's free trial with no strings is also attached. News of the Times, historical crime at patreon.com. This has been News of the Times, and I am Robin Coles, Assistant Keeper of the Gavel Wax, Deputy Sub-Inspector of Improper Bonnets, and Honorary Secretary to the Society for the Prevention of Overly Dramatic Elopements.